welcome back everyone to the Deebrook School of Law. Now this is part 3214. So make sure you get all your pieces in order. When we pass out this manual, we don't, we're just throwing it out there at you. You got to put it in order for yourself, okay? Now, we're going to go over some more training manual videos today. Mr. Brooks today is going to talk about the plaintiff. Now, Mr. Brooks was so clever right here. He brought up some really good stuff that we're going to touch on. And as you know, throughout this trial, he has been very adamant on the fact that the plaintiff is not showing up in court. We can't see them. We can't hear them. And Mr. Brooks is going to touch on a couple of things here that you guys need to pay attention to. And we're going to watch his trial footage so you can learn from the man himself.
Calling State of Wisconsin versus Darrell E. Brooks, case number 21 CF 1848. May I have the appearances, please?
Morning, Judge Sue Daisy and Zach Waukesha appearing for the state.
Sir, would you please state your name for the record?
I'm here as a third-party intervener in that matter, appearing as authorized representative for my client. I accept for value in return for value all of the charging instruments in this matter and make my exemption available for discharge of all obligations and charges connected with this case. I do not dispute any of the facts in the charging instruments.
Right, the record should reflect that the individual known to this court as the defendant, Darrell Brooks, is present in court. He's in custody, but he is wearing street clothes. He's wearing a suit and tie and a mask. And good morning once again to everyone.
Also for the record, I do not identify by that name or consent to being called that name.
So noted. All right, Mr. Brooks, do you have a 13th subpoena? As we discussed yesterday, you wanted to call 13 witnesses. I told you had until this morning to fill out another subpoena and give it to the state so that they could review it.
Yes, I do.
All right, can you hand that to the bailiff, please? I'll just take a look at it quick. Mr. Brooks, I'm reviewing this for completeness, and you have simply put on here State of Wisconsin plaintiff. That's an entity. You have to name a person, sir. So I'll have it shown to the state, and they can let me know their position on that.
Any legal basis why that would not be accepted, Your Honor?
You have to have a person named, sir, so that they can come and testify. You only have an entity named.
Is it not true that under the Sixth Amendment I have the right to face my accuser?
Mr. Brooks, let me hear from the state.
Yes, Your Honor, I agree with the court's assessment. The subpoena does not state a person. The subpoena form specifically indicates that the person requesting the subpoena is to indicate the witness's name and address. Mr. Brooks has simply written the word State of Wisconsin plaintiff for the witness name. The State of Wisconsin is an entity. It's not a person. The State of Wisconsin cannot testify at these proceedings, so the subpoena should be rejected, Your Honor.
Your Honor, on the grounds that every document that was filed in this matter stated that the State of Wisconsin was the plaintiff, which would lead me to believe that the State of Wisconsin is who's bringing the claim against my client. How could they not be subpoenaed to testify if they're the plaintiff? And under the Sixth Amendment, I have the right to face my accuser. My accuser in this matter is the plaintiff, which is the State of Wisconsin. Attorney Opper also brought up that It didn't have an address on there. None of my subpoenas had addresses, as we went on the record, and that was stated that a lot of the paperwork that I have don't have a lot of the people's addresses on there, and those subpoenas were accepted. So I don't see the difference with this subpoena not being accepted for the reasons that Attorney Opper just stated.
Do you see what he just did there? Do you see how brilliant that was? Now, there's a couple of reasons why Mr. Brooks did this. Number one, he is delaying. Now, y'all know he's really good at that. So if you don't get anything else out of Mr. Brooks' trial and watching these training manual videos, it's going to be learn how to delay your trial. Secondly, Mr. Brooks has provided information and court recordings that are going to be essential in his appeal of his trial. Okay, so if you get convicted, which you probably are, this is going to help you with your appeal after the fact. So sometimes you got to think long term. Bite that bullet, so to speak, and then we're going to move forward and. Yeah, we're going to talk about the rest of it here. Let's just move forward and talk about, I'm going to show you some other points as well.
Mr. Brooks, in relation to that subpoena, based upon my review for completeness, this court would note you have not named a person, you've named an entity, and the subpoena will be kept on file as part of the court record, but I'm not going to require the state of Wisconsin to testify in this case because they are an entity and you have not named a person.
Are they not? Or are they not the plaintiff, Your Honor?
They are the plaintiff in this case, sir.
And why are they not able to testify, being that they...
Sir, you've named an entity, not a person. People are called to the witness stand to testify. You have had an opportunity to cross-examine every single person who has been called by the state to testify in this trial. I believe that your Sixth Amendment rights have been complied with.
Not if I'm not allowed to face my accuser, Your Honor. My accuser in this matter would be the state of Wisconsin. And with all due respect... Sir, I believe
your Sixth Amendment rights in that regard have been complied with.
I'm requesting a written judicial finding of fact and conclusion of law on this issue for the grounds that I just stated. It was seen, based on the Sixth Amendment, that I'm not being awarded the chance to face my accuser, which I should be awarded that based on the Sixth Amendment. If I'm not able to face my accuser, then how can a claim even stand? How can a claim be brought against my client if I'm not able to face the accuser?
So this case is a criminal case in a court of competent jurisdiction in the state of Wisconsin, Waukesha County. This case was initiated initially by the filing of a criminal complaint. Then there was a preliminary hearing where probable cause was found. After that point, there was an information that was filed. And at some point, an amended complaint, perhaps even a second amended complaint, was filed as well, putting you on notice of the charges and the factual basis for those charges, along with the statutes that are alleged to have been violated. I'm not going to explain any further why you can't call the state of Wisconsin in the way that you've subpoenaed them or attempted to subpoena them for the reasons I've already stated. I understand where you might disagree with the court's ruling, but my ruling stands, and I'm not requiring the plaintiff in this case to serve that subpoena in any way for the defects I've already noted.
May I state for the record?
And I'm also not going to issue a written decision on that. The record speaks for itself.
May I state for the record, Your Honor, that I have not even seen a complaint in this matter, and the jurisdiction still has yet to be proven, which is another thing that needs to be challenged. There has not been proven that there's subject matter jurisdiction as of yet. there's no verified proof of it. There's no verified proof of even a claim, especially if I'm not allowed to face my accuser.
Now, did you see what he just did right there? He twisted that, turned that around so quickly. This man is amazing. How he can just change from one topic to another, just like it, just on a like just a spin of the toe, just a pinpoint, just a point. It's just amazing. It's just amazing how he can just flip the script and change on to one more topic. And you need to be quick-witted like that, just like Mr. Brooks is, because when one argument fails, then we're going to pick up and go straight into the next argument, which of course is subject matter jurisdiction. It's always been his main argument, and he, to this day on his appeal, still has that information within there. Let's continue watching.
I don't understand how you can make that judicial decision, Your Honor, when it's clear discrepancies in the paperwork of this matter. Like I said, I have yet to see jurisdiction be proven. It has not been proven. I have yet to see a complaint. I have not seen that.
The court has provided you with, I believe it was the second amended criminal complaint, along with the information that was provided to you previously and noted on the record. I've already addressed your motion to dismiss previously. I'm not going to revisit that. There's no legal basis requiring me to do that, sir. The plaintiff in this matter has presented witnesses to establish venue. And again, as I've noted previously, it's a criminal case with criminal charges, with a second amended criminal complaint detailing the factual basis upon which these charges are based. We're a notice pleading state, and along with the information, you've been made aware of all of the charges and the penalties you face and the factual basis upon which the state has brought these charges. We are in the middle of trial. Your objections are noted. We will continue today with the jury trial.
For the record, may I respectfully move for interlocutory declaratory appeal on this matter, Your Honor?
Your request is noted for the record. I'm not an appellate court, sir.
For the record, may I move to stay these proceedings until this instant matter is adjudicated by a court of competent jurisdiction?
Your request is denied.
Based on what law or fact, Your Honor?
I've previously addressed the issue, sir.
So
based on law of the case.
Are you making a judicial determination that I'm not awarded my Sixth Amendment right to face my accuser?
I'm not making any such determination here today. All right.
What law or fact?
I'm going to turn to the district attorney's office. Do you have a witness available?
Yes, we're ready to proceed, Your Honor.
All right, our jurors here. All right, the jurors will be brought out, sir.
Your Honor, with all due respect for the record, you're avoiding my questions.
Mr. Brooks, I've addressed the issues that need to be addressed this morning. I've also addressed the same issues probably every day we've been in court. I know you may be dissatisfied with the response that I'm providing to you, but my responses stand.
It's not a dissatisfaction, Your Honor. It's a lack of understanding, which I don't have. I don't even understand the true nature and cause of the charges. And without...
Mr. Brooks, you've been made aware of them multiple times.
I do not understand them, is what I'm saying.
I encourage you once again, if you don't understand anything, to seek the advice of an attorney. I cannot give you legal advice.
I'm not asking for that, Your Honor. I'm merely asking why are my constitutional rights being prejudiced? It states under the Sixth Amendment that I have the
Sir,
right...
I've already addressed this. Okay? We're not going to have any further argument on this topic. All right? Your Sixth Amendment rights are being honored no differently than any other defendant that has appeared in my court.
Have any other defendant not been awarded the opportunity to face their accuser?
You are facing your accuser, sir. Every single witness who's been on this stand, you have cross-examined.
None of those witnesses are making a claim. None of those witnesses are the plaintiff. None of those witnesses are identified as the injured party. an injured party has to make the claim, Your Honor. A
So it's
living.
my opinion that your belief as it relates to that is mistaken. It's not a lawful argument, and it's frivolous. I've directed your attention once again to the Beneby decision.
Well, we want to thank you for watching today's video, and we hope that you are going to learn something that's going to get you off your charges as well. And if it don't get you off your charges, well, at least you've been able to delay the court so that you can stay there more often. But I think the food's kind of better there when you're in court versus when you're in the jail, and you know, kind of gives you a little bit more comfort while you're having to you know, throughout your sentence, and it just kind of breaks the monotony of being in jail up a little bit. So yeah, that's great. Now listen, Mr. Brooks is going into another trial here coming up soon on some other previous charges. And listen, y'all be good, and we'll talk to you in the next video, okay? Until then, don't forget to practice how to change topics with the blink of an eye.